Boom, Anna Esibu, so Deputy Head Justice Ramsay and the Chief Justice Boahene clash with the GBA. And that's some Ketwene, Bibi Kosi were caught in the 291 million MPA scandal. Babachero Mustafa Hamid case in the lawyer Echo Court. Irak Penka Wakasa. Chief Justice and Swabe Kasa, Deputy Attorney General Kasa. Court to say on Kwabena Adu-Boahen 6 days, and 11th, 17th. One for lawyer Ama obey case, which is next week Monday. Atta Akyea court. Then you could see exclusive. I'm the bro in this video. To make sure, so subscriber, more subscriber, no click the notification. The video be to Bawumia. You have a comment, feel free leave that comment in the comments. Especially so because Goldberry Construction Limited. Other episodes in assassin krata some the documentations related to your house and Goldberry. ABDC money in Adia man. We are back home assessor. Any assistance you need for your home. You are abroad, you need someone to assess some business enterprise for you. Probably boko asase to akwachama asase no obi enko so unhi obi beton asase amount unyan obi a wo si dan obi check bibia de amount back assess. So message me from bibia be kama. I apologize for changing the background. If I jam light nti enko so now enra ana GBA e de letter e buy now. Letter no more the buy newa. Mini light inti I don't have the luxury to do a lot of analysis. But other than the summary of the letter is say they don't agree with the Chief Justice said there should be substantive cases being heard whilst the courts are on vacation. The letter was signed by Akyea, who is the president of GBA. The first person of Kasa is Chief Justice Boahene. Or apply GBA and continue your kind.
To write to the Chief Justice to say that the cases should not be adjourned to the vacation. So I cannot come. I have already made agreements outside, so I'm not coming. You are a lawyer. You have your clients. If your clients decide to leave, well, go on leave. But you cannot say that there's a legal vacation and the judge who is actually sitting cannot do your case. No, that's not it. And then adjournments are not at the instance of the Chief Justice.
Yes, that's what a petition Atta Akyea money at the Akyea there. Pay the response wouldn't use a petition, no. Invariably, no answer more than that. Those are no answer officialities, answer you. But penny okay there. No, court no. Ana judge Achebonga, a friend of the National Service. Stand up. And I Boahene is not so lawyer when no so long as a Chief Justice the Tenase. On fire warrant to be a matter may Tenase bill. It's Monday, one produce someone Atta Akyea. Why will be general cross examination? Because public prosecution witness one regional dakem. As someone Atta Akyea interrogating. Judge and say. Se samu Atta Akyea ma court Monday na brantie na so Kwabena Adu-Boahen nkopɛ lawyer ame gire ni mu a Monday no abɛ cross exam no free court no the Deputy Attorney General Ramsay enso kan eni.
No genuine or real controversy here. The matter is simple. It's been the case that vacation courts are always sitting whenever there is a legal vacation. No one can dispute that simple fact. They claim that it is the lawyers who decide whether they want to have a proceedings in vacation. Is not founded on any fact. It's not founded on any law. It's not founded on reason, and it is not founded by any rule of practice. Lawyers, nowhere in the world do you see lawyers deciding when a court should sit. What matters is that the head of the judiciary has given warrants for a number of judges, I think 10 or more judges, to sit across the country to take care of cases. Now this is a thing. A vacation judge has his or her own courts to administer. Okay. Now when the vacation is over, he is also entitled to go on vacation. That is after October. Now if you make the argument, as the GBA president is making, that a vacation judge is not required to, or cannot hear cases or conduct trial, then when the vacation is over and he goes on vacation, no other judge can have trial. So basically what the GBA is saying is that for cases that are pending in the courts that have vacation judges, those cases can only conduct trials in January next year, because in October, when the courts return, these judges who are sitting on vacation would also go on vacation, and no judge can conduct their trial for them. And then after October, November comes the December vacation, which takes us to January, first, second week in January. So you will see that apart from the fact that there is no practice backing what the GBA is saying, it's not supported by law, by any rule of practice. And again, it's also supported by reason that would be positive or advance the cause of justice. So for us, it is a self-imposed understanding of the law, which we do not think should be allowed to prevail. And as the judge said, the vacation is, he has the warrant to hear the case and sit in vacation. And if you don't come, he will treat it as if you are not interested in legal representation, and has given directive to the clients to advise themselves. If their lawyers decide that they won't practice, no one can stop them, but he has a case to defend. If on the next agenda date he does not produce, I think the judge has given them 1 week. If they do not produce a lawyer, then they will have to conduct the cross-examination by themselves.
Deputy, so it basically in simple terms you mean that the GBA got it wrong in their statement?
Completely wrong. Completely wrong. And the claim that there is a convention is completely even false. There's no such convention. And even if there is a convention, Order 79 of CI 47 is the order that provides expressly for legal vacation.
Yes. Now, National Service, MP in Scandal, Kojira Mustafa Hamid, former Information Minister, former Minister for Zongo Development, New Affairs Vice Chair, and the case now MP or MP is scandal. And also, course, you could see your court according to the lawyer, Ensu Ili.
In absolute respect to the court, because unless again did, we agreed to meet today to continue with CMC. However, as a result of certain circumstances, we were anticipating that the case would be adjourned to October. Because, of course, counsel for A1, my good self and my team, and then A2, A3, and the other accused persons were all present, except counsel for A4, A5, A7, and A8, who had traveled outside the country and written to the court asking for an adjournment to October. But same was rejected by the court, and the case had been adjourned to the 18th for us to continue with CMC. Well, we had written to the CJ, we petitioned the CJ that we had prior commitments. As a result of the vacation, we anticipated some had commitments here in the country and outside of the country. And we have petitioned the CJ, but there's no reply to that effect yet. So while we await that, the Honorable Court was right in its wisdom to say that until a determination is made by the CJ rejecting or accepting the request to adjourn to October, he's going to continue to sit because he has to comply with the directive and warrant that he was given. And you were in court. Initially, he suggested the 17th, but after we made further applications, it was adjourned to the 18th for us to continue with the CMC. And as I indicated, it is particularly lawyers for A45, A7, and A8 who were absent and had written to the court indicating why they could not attend.
But you petitioned or submitted these petitions last week or so. Do you intend to follow up on the progress of this?
Absolutely. We intend to follow up at the office of the Honorable Chief Justice to find out exactly what the decision is, whether or not our petition is receiving a positive outcome or a negative outcome. They need to be able to help us know how to plan ourselves for the holidays. If it is rejected, we have other rights that we can exercise, and nothing is being ruled out. But we are of the conviction that the Honorable Chief Justice will exercise his discretion by granting and acceding to the petition that we have actually written and asking that the case be adjourned to October so that we come back. We are ready anytime for the trial, but as we have all indicated, we all have plans for the legal vacation. And so if you have your prior commitments, some have medical commitments, some have programs outside the country and elsewhere. And so to be able to vacate those plans that you had suddenly when some had even if you look at the one who wrote to the court, it was very clear that they attached flight tickets and all that. They had commitment to be out of the country. But as I again put it, the judge exercised his discretion by saying that, look, he is bound by the warrant and he's going ahead to hear the matters. And whatever the court decides, we cannot abandon our clients. We have to abide by it because we are in court seeking to clear the situation, as it were, and make sure that our clients walk home. And so if the court decides that we should come to court and we say we will not be in court, whatever decision they take will affect our clients. For me, we are very much ready, but we just want the Honorable Chief Justice to exercise his discretion according to Article 296 and 23 and grant a receipt to cut the Courts Act, particularly Section 79, thereabout. It gives him the discretion to take certain decisions for sittings of court, including weekends and holidays, etc. The problem I have, which I have stated without equivocation, is that you realize that there are only two specialized courts, and they are the only two courts that are sitting during the vacation to hear substantive trials. I think that one thing I've realized is a number of people are getting confused between the substantive hearings and motions. You know that during the holidays, judges do not normally deal with the substantive hearings. It is only motions. So the holiday judges sit to hear motions and urgent applications. But if you look at the two specialized courts, they are asked to do normal hearings that we do during the normal period that we are in court, as against the vacation. So if you ask me, it's novel. We've not done that before. The convention has been that we go on vacation at the end of July and come back in October for substantive trials. But a few judges are selected to sit to hear motions and urgent applications only. So what is happening now, with all respect, is novel. Especially so when you realize that the cases that are pending in these two courts are all of a political nature. You know, because respectfully, we have so many cases, some of them 10 years, 15 years, 20 years, very serious cases, murder, land matters, civil litigation, criminal litigation. So many cases, very important cases that have been in the shelves for years. But these cases started, the majority of them started a year ago. So why the rush to hear those ones to a conclusion? That's the question. Because the exercise of discretionary power has to be in compliance with Article 296 and 23. So if you exercise it, there must be a basis for it. So we are saying that in the circumstances that we have now, the Honorable CJ should review his decision and allow for us to come back in October. But if he declines, we ought to comply.
Thank you.
We have no choice.
Thank you very much, Counsel.
Yes. Ntono they will say yes, my client, you know, I don't agree with the vacation, but I'm because me knew I did bet me there may be a negative repercussions for my client. I think I've shared my view on this. I think that, as I said, they need to judge with the Chief Justice. I'm being told that these things are not new in the system, but that sometimes they don't hear substantive cases. Sometimes, in fact, my lawyer tells me that there have been instances where some substantive cases have been heard. But he believes that because of maybe the political nature of these cases, you know, that is why they are going this way. But for me, even the political nature of the cases, sometimes I struggle. These are individuals. And the law is not as if you MPP have been arrested and there are certain charges are due against the person. So in the political cases, I struggle to see where we draw that. But if we are not careful, we will politicize everything. It's a discretion for the CJ to make, and though the constitution said that the decision must be capricious and all that, but I believe that the lawyers vacating the court totally, I find it a bit some way. But I also believe that the Chief Justice must hear them. Maybe they need to be a certain discussing. As for the GBA, and I don't want to highlight matter because of the whole perception. I've done this analysis, but I think that they themselves need to do a bit of introspection of some of these matters and all that. But that's their view. I mean, they are lawyers on what come brothel, and they are disagreeing on a lot of the issues. But this is why the GBA is trending. This is why the Chief Justice is trending. This is why Dr. Shamsa is trending. Sorry, I couldn't do a longer video for you because I don't have enough power storage. So more friend me. Make sure also be subscribe. I'm for view, bra. In on this subject, am I? We are. Now subscribe. I'm subscribe. Now click the notification with the video. Be able to next watch. Make sure so be sure see the mama me here. Ghana see here. Bye bye.